Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Firdaus Ashraf bin Yahya. My metric number is AP180315. So my part is about introduction, law of thoughts in construction law. So a thought is a common wrong that happen where somebody unjustifiably make someone else endure misfortune or mischief. An individual submitting a thought is lawfully subject to the gathering harm who is given a cure in law. The purpose of thought is to restore victim for damage incurred and to discourage potential violators from repeating the same offense. There are many types of thoughts, but we will focus on the three categories thoughts fall into. The first one is intentional, the second one is negligent, and the last one is strict liability. So that's all from my part. Thank you.
Construction law is a branch of law that deals with matters relating to building construction, engineering, and related fields. It is in essence an amalgam of contract law, commercial law, planning law, employment law, and tort. Construction law covers a wide range of legal issues, including contract, negligence, bonds and bonding, guarantees and certificates, client and other security interests, tendering, construction claim, and related consultancy contract. Construction law affects many participants in the construction industry, including financial institution, surveyor quantity, surveyor architecture, builder, engineer, construction workers, and planner. That's all. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Umi Aida binti Alias. The matric number is AP180318. Today I want to explain about my part is definition of tort in the construction law. A tort is a severe wrong that occurs where someone unfairly causes another person to suffer loss or harms. Type of torts in the construction law have three types. Intentional torts. An intentional tort is when an individual or entirety properly engaged in conduct that occurs injury or harm to another. For example, tricking someone in a fight would be considered an intentional act that would fall under the tort of battery. The second type of tort in the construction law is strict liability. Liability applies to case where responsibility for an injury can be imposed on the wrongdoer without proof of negligence or direct fault. The third type of the tort in the construction law is negligence. There is a specific code of conduct which every person is expected to follow and a legal duty of the public to act a content way in order to reduce the risk of harm to others.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Danish bin Ayub and my metric number is CP180039. I will present about the clause of law of tort in the contract document. Okay, first is the CIDB form of contract. It is stated in clause 17.2, which is the possession of the site, where the contractor is given the date of commence prior to the contract document, prior to what is stated in the contract document. Next is clause 17.3, where the failure of notifying contractor about the date of commence, and the contractor need to notify the superintendent officer SO about the failure of notifying, because it will be affect their extension of time, the EOT. Next is the 17.4, where the right of way of access, where the contractor is responsible is allowed to find any way to make in the contract in the construction site, but it is the responsible of the contractor, and the pay is need to be out from the contractor itself. Next, it will be continued by the Dinesh. That's all. Thank you.
So the next will be the standard form of design and build contract, PWD. So in this contract, these trespassing cases will go under the law possession of site. So it is stated in clause 12.1, 12.2 and 12.3. It's about when the contractor or the employee can enter, when they should leave the site, and what's the legal ways to do so. So in clause 12.4 is about the delay in giving possession of the site to the particular person to carry out the work. And in clause 12.5 and clause 12.6, it's just related to the clause 12.4 we've seen just now. So it's about the delay in giving possession and what the step needed to be carried out to address such situation. So the next one will be the PAM Conditions of Contract 2006. So it's about the date of commencement. Possession of site will be given to the contractor who will commence the execution of works regularly and diligently. So the last one will be the JKR's 203A Conditions of Contract. So it's almost the same as the previous contract we looked just now. So it's about the possession of site. So it's also stated that possession of site as complete as may reasonably be possible, but not so as to constitute a tenancy, shall be given on or before the date for possession. So that's all from me today. Thank you.
My name is Lee Jie and my matrix number is AP180356. And today I will present about 5 trespass cases that happened in construction site. The first case was happened in Singapore. 2 China construction workers were climbing up themselves to the top of 2 crane towers at the work site to threatening their employer because they are unhappy with the arrangement made by the employer. The court was made a decision that they could have jail for up to 3 months and or fine up to 1,500 each. The second case was happened in America. A pair of men and women was trespassing into a construction site, and 2 of them were jailed at Lake Country Jail of America, and 1 of them was fined $2,000. The third case was happened in Singapore. A Chinese national male was trespassed into a construction site and climbed to the top of crane tower because unhappy with the salary dispute from the former employer. Based on the court, the man was charged for the criminal trespass under section 447 of the Penal Code, which carry a maximum of 3 months imprisonment upon conviction. The next case was happened in Singapore. A man was arrested by the police after the police have received a report that he carrying a bag was behaving suspiciously at the construction site. According to the investigation, the man was involved in the previous case of theft report at the same construction site. According to the court, the man will be charged with the offense of criminal trespass under the Penal Code. If the man was convicted, he will be jailed up for 3 months or fined up not more than 1,500 or with both. The next case was happened in Singapore. A Chinese national charged with criminal trespass after he climbed up a crane in a construction site to get attention from the project manager to hand over 1,500 to him. His passport was impounded by Singapore government, and based on the court decision, if he was convicted, he could jail up to 3 months or fine up 1,500 or both. Thank you.
Good morning. Now I want to talk about the recommendation of the law of touch. The first recommendation of the law of touch is keep outside post. We keep the site in the post at the construction site, so we can prevent the people enter the construction site to steal our material, such as wood, concrete, and steel. So we can prevent the trespasses in the land, in the site, and the keep post signpost can prevent and alert. Now, the second recommendation is mount required fences. With the required fences, we can block the construction site with the property, and we can protect our material well and prevent the trespasses in the land. The trespasses in the land is mainly happen in Malaysia because the material in the construction site is very valuable and it can be sold to another contractor in the lower prices. So it may have many happen in trespasses in the land. So the third recommendation is install camera and alarm. So this is the most important because install camera can detect who is distilled and come into the land and construction site. And with the alarm, when some people is enter, the alarm will give a sign and recommend to the neighborhood, and it can prevent the trespasses it happen in the construction site. So this is the 3 recommendations that I to suggest for the law of touch about the trespasses in the land. Thank you.
Okay, hi, Assalamualaikum. My name is Muhammad Nufri Idris. My metric number AP180320. Today I will explain about the conclusion of the assignment that we make together with our teammate. It is about the law of tort. The law of tort is a collection of civil law remedies entitling a person to recover damage or loss and injury which been caused of the action, omission or statement of another person, which is such a circumstance that the latter was in a breach or duty or obligation imposed at law. The tort of negligence is concerned with a breach of a duty to take care. In order to success in an action of negligence, a plaintiff must prove 3 things. The first one is defendant or owe to the plaintiff a legal duty of care. Number 2 is the defendant was in a breach of duty, and number 3 is the plaintiff has suffered damage as a result of the breach. Okay, when we talk about the thought of the project, we have to apply the context in the construction in a project. The principle of thought of law must also take into the account of the application of the key related legislation in a particular part 2 of the Housing Grant, Construction and Regeneration Act 1996. Okay, next, the liability of tort have their issues, and every issues have their own conclusion. There is a certain step that we have to make to mitigate the liability of tort. Firstly, we have to causation. The first step is causation. The second step is remoteness forcibility. The third step, intervening act or event. The fourth step is the mitigation of damage not taken by plaintiff. For every construction site, have to follow the law that have made by the government and the authorities, because the law have to give the good thing and have to make the project run smoothly. That's all from me. Thank you.